A very good evening to you, ladies and gentlemen. It is my honor and privilege to warmly welcome you to the 111th webinar of the Bar Association of Sri Lanka. Initially organized under the Secretary's Office and now by the Seminars Committee of the BASL, these webinars are conducted 4 times a week. To give you an insight, the English webinar series is conducted every Saturday at 5:30 p.m. The Sinhala webinar series every Tuesday at 7 p.m. The Tamil webinar series on Thursdays also at 7 p.m. And today's professional, personal, and career development webinar series is conducted every Sunday at 7 p.m. The BASL webinars were the brainchild of the BASL Secretary, Mr. Rajiv Amarasuriya, and has been running continuously since May 2020. Today's webinar is organized by the Professional and Career Development of the Women's Lawyers Committee and supported by the Seminars Committee. We would like to thank the chairperson of the Women Lawyers Committee, Mrs. Indika Nagaratna Kottagoda, Attorney at Law, co-chairperson, Ms. Nalani Manatunga, Attorney at Law, convener, Mrs. Aparajita Aryadasa, Attorney at Law, and co-conveners, Mrs. Umeshika Dalapatadu and Ms. Vindika Subasingha, and the other members of the BASL Professional and Career Development of the Women Lawyers Association. We also thank the Seminars Committee of the BASL, chaired by the Secretary of the BASL, Mr. Rajiv Amarasuriya, with the Convener Assistant Secretary, Mr. Pasindu Silva, and co-conveners, Mr. Pandula Vanniyarachi, Mr. Oshan Ubeyaratna, and Ms. Anne Devananda and Ms. Nikini Mapitigama. I would also take this opportunity to thank the President of the BASL, Mr. Salia Piris, President's Council, and the other members of the management committees of the BASL for all their support and guidance given. Throughout these webinars, we've seen some of the most brilliant legal minds in the country share with you their knowledge and experiences, and today is no different. Our topic for discussion today is the art of advocacy and court craft. This is indeed an interesting area and also a crucial area of focus for an attorney at law. And I have no doubt that there is much to learn from our amazing panel of experts this evening who have had immense success in their respective careers. It is indeed my privilege and pleasure to welcome them all today. Before we proceed, however, let me give you a brief introduction to our panelists. First and foremost, we have with us Mr. Sanjeeva Jayawardena, President's Counsel. Mr. Sanjeeva Jayawardena was called to the bar in 1992. He was thereafter conferred silk in 2012. For the last 29 years, Mr. Jayawardena has exclusively practiced in the Supreme Court and the Court of Appeal. He specializes in all aspects of appellate law, as well as constitutional and public law, and has a varied practice in diverse fields and subjects, including civil, contractual, commercial, property, taxation, banking, labor, and other disciplines of the law. He is an honors graduate in law of the Faculty of Law from the University of Colombo, and has also secured a master's in philosophy in law from the same institution, and is a doctoral candidate in the PhD degree program of the Faculty of Law, University of Colombo. Mr. Jayawardena is a member and also the first President's Counsel to serve on the Monetary Board of Sri Lanka. He is also the chairman of the Monetary Board level External Debt Monitoring Committee, which monitors and makes recommendations with regard to the management of the foreign debt of the country. He is also the chairman of the Monetary Board level Risk Oversight Committee, as well as the chairman of the Ethics Committee of the Central Bank. Mr. Jayawardena has been serving as a Commissioner of the Law Commission of Sri Lanka from 2015 up to date. He is also a serving member of the Committee of Experts appointed by the Cabinet of Ministers and the President to draft a new constitution for Sri Lanka. He is the current chairman of the Presidential Experts Committee on the implementation of the data protection in Sri Lanka. Mr. Jayawardena also has several published papers authored by him. Aside from this, he has also co-authored the book titled Women and Violence. We are privileged to have you with us today, sir. We also have with us Mr. Varuna Senadira. Mr. Varuna Senadira is an attorney at law who has completed 29 years of active practice. He specializes in the law of banking with emphasis on money recovery litigation, labor law, property law, commercial law, company law, finance law, administrative law, and public law. Throughout his practice, Mr. Senadira has appeared as counsel in the original and appellate courts for several renowned corporate clients. Most recently, he also led the team of lawyers who filed 182 civil actions to claim damages before the District Court of Negombo pertaining to the deceased and the injured of the Easter Sunday bomb attack, which took place at St. Sebastian's Church, Katuapitiya, Negombo, on the 21st of April, 2019. Mr. Senadira is also a member of the Bar Council of the Bar Association of Sri Lanka and a member of several advisory boards and committees. To His Eminence, Malcolm Cardinal Ranjit, the Archbishop of Colombo. He was also a member of the Ethics Committee of the Bar Association of Sri Lanka. Mr. Senadira has authored articles that were published in several law journals. He was also a lecturer and examiner in international law at the Open University of Sri Lanka and also worked as a lecturer in banking law at the Institute of Bankers, Sri Lanka. Mr. Senadira, we are happy to welcome you today. We also have with us Ms. Nurani Amarasinghe. Ms. Nurani Amarasinghe holds an LLB from the University of Colombo and accounts for 28 years of active practice in the original court and the Commercial High Court, the Civil Appellate High Court, and the Supreme Court. Her practice spans across Colombo and the outstation courthouses. Her areas of expertise include land law, partition, divorce, money recovery, rent, and injectment, to name a few. We warmly welcome you on board, madam. Also joining us this evening is Mr. Mohammed Adamali. Mr. Mohammed Adamali was admitted as an attorney at law in 1994 and has completed 26 years of active legal practice. He is also a graduate of the Faculty of Law, University of Colombo, with honors. Mr. Adamali commenced his practice in the chambers of Mr. Jeffrey Alagaratnam, President's Counsel, and subsequently established his own chamber, handling civil litigation in commercial, labor, construction, family law, injunction matters, commercial arbitrations, drafting of contractual documents, and negotiation of commercial contracts. He also specializes in foreign investment advisory, business setup services, and corporate acquisitions. Mr. Adamali has served as a visiting lecturer of the University of Colombo and at the Sri Lanka Law College Practical Training Program, and has also been a resource person, presenter at various law and related conferences, seminars, and webinars. The judgments of the superior courts delivered in several appeals, Mr. Adamali has argued, have been reported in the Sri Lanka Law Reports, the Bar Association newsletters, and the Bar Association law journals. Mr. Adamali has also authored papers primarily on labor law in several law journals. Mr. Adamali has also graduated from the Chartered Institute of Marketing, UK, and has lectured in marketing for over 30 years and in management accounting, CIMA, for over 10 years. He also serves as a director or independent director on the board of several listed and unlisted companies in the banking, hospitality, and leisure sectors. He is also a leading thespian, the founder and producer of the performing arts company, and an actor, director, and producer for over 50 stage plays and several films. He is also an accomplished orator and internationally invited public speaker. Mr. Adam Ali, sir, we are privileged to have you with us this evening. Finally, we move on to our moderator for the evening, that is Mr. Janaka Basuriya. Mr. Janaka Basuriya is an attorney at law who handles an array of legal work ranging from commercial and civil litigation, legal assignments, commercial arbitration, customs inquiries, drafting commercial legal agreements, company secretarial work, IP agency, and consulting corporate enterprises and companies. He is also a Bachelor of Arts honors graduate from the University of Kelaniya, Sri Lanka, specializing in the French language. His areas of expertise include various aspects of company law, commerce and trade law, investment law, intellectual property, contract law, drafting, reviewing, managing, and advising on various types of commercial contracts, documentation agreements, both locally and internationally, to name a few. Whilst working as a commercial officer attached to the French Trade Commission of the French Embassy in Sri Lanka, Mr. Basuriya handled international trade and commerce-related work and was also engaged in the preparation of reports, agreements, and engagements. Currently, he functions as the legal advisor, le consul avocat, to the Embassy of France in Sri Lanka and Maldives, and provides his services to many French and or European companies and organizations. Mr. Basuriya is also the founder director of Tribe International Private Limited, a company that provides total corporate solutions to local and international corporates. Mr. Basuriya has also worked as a legal associate at WNS Global Services, a pioneer BPO and LPO service provider in the island. Being passionate about international commercial arbitration, he also provides his services as a commercial arbitrator, mediator, and facilitator. Mr. Basuriya is a trained arbitrator at the Chartered Institute of Arbitrators and a commercial mediator. Mr. Basuriya, we welcome you on board. So, without further ado, ladies and gentlemen, I will now hand over the reins to our moderator. I hope you have an interesting and enjoyable session. If you have any questions, please send them in via the Q&A box. Mr. Basuriya, sir, over to you.
Thank you, Joshua, for that generous introduction. As you stated, today's webinar is a very significant one, as it is the 111th of its kind organized by the Bar Association of Sri Lanka. We must congratulate the BASL and the office bearers of the Professional and Career Development of Women Lawyers Committee of the Bar Association for organizing this webinar. And it is also a pleasant coincidence that all four speakers tonight happen to be batchmates. And I am sure that they may have some interesting memories to be shared with us tonight. Ladies and gentlemen, our first speaker for today, as you know, is Mr. Sanjeeva Jayawardena, President's Counsel. Before we move on to Mr. Jayawardena's speech, let me quote a famous saying of Jim Rohn, an American writer. I quote, "If you are not willing to risk the usual, you will have to settle for the ordinary," unquote. Which means to say that you may die a good lawyer, but to be a brilliant one, it takes a little bit more to it. I'm sure Sanjeeva sir will share with us those little things that matters a lot. With that, may I humbly invite Mr. Sanjeeva Jayawardena, President's Counsel, to share his experience and wisdom on the trajectory from being a good lawyer towards a brilliant lawyer, with special emphasis on appellate court practice. Over to you, sir.
Thank you, Janaka. Thank you for that introduction. You have asked me to speak on from being a good lawyer to a brilliant lawyer. I don't know whether you presumed your initial predication on which you have made that topic and referred it to me is erroneous and presumptuous. But I will nevertheless try to oblige you. I just asked, you will recollect yesterday I asked you and Anne what the general demographic of the participants were. So if I'm not mistaken, I was told that there will be a significant group of younger lawyers as well. So I will also have them in mind specifically when I'm saying what I have to say. So let me tell you a few of very briefly, my experiences, because I'm going to speak on being an exclusive legal practitioner in the appellate courts and the Supreme Court. So let me tell you how I got to where I was in terms of actually concentrating on those two courts. I started off my career. I was supposed to apprentice in the Attorney General's department, but for whatever reason, I decided to decline that. And then I started working with Mr. R.I.O.B. Sekara. Actually, my first brief was given to me by Mr. I.S. De Silva, who it was a civil trial, and I was junior to him and that. But as a permanent arrangement, I started off my career with Mr. R.I.O.B. Sekara, President's Counsel, and Justice Arjun O.B. Sekara, who was my good friend, is the one who put me in touch with his father. And I started off, therefore, doing criminal law. So I went with him to the High Court. I went with him to the Court of Criminal Appeals. And then I myself started doing arguing several cases in the Court of Criminal Appeals. And whilst doing that, I happened to stray, because as most of you know, Court of Criminal Appeals is in court number 107 at the ground floor of the Supreme Court complex. And it was very interesting because the bench was Justice D.P.S. Gunasekara and Justice Sarath Silva, who graduated to, being the Chief Justice and a Supreme Court judge. And they were master prosecutors in terms of their experience. And when I did cases before them, it was such a daunting task because they were 2 steps ahead of you in everything you did, being with their special experience. But I enjoyed it for some time until I came across a particular case where I did, it was a murder case. And there was the accused was the uncle of a little child who had been abducted at Golface Green. And it transpired that the prosecution was that he had strangled this girl together with an accomplice, having spirited her away from Golface Green. And then I'm just trying to tell you this because this is a watershed turn in my career. And then he was the first accused. The accomplices were the second and third accused. All were sentenced to death. And the matter came up before Justice Amir Ismail, who was sitting in court number 107. And I can't remember who the second judge was. And I was personally convinced that there was no evidence against him. And this was actually referred to me by Justice Shirani Tilakavardhana, who was at the time a High Court judge. And the matter had come up for some consideration of an application. She called me and said, Sanjeeva, can you please handle this? Because when he came up before me, the first thing that struck me when I just went through it was that this boy seemed to be innocent. She didn't have any connection with this accused at all, but she just felt that her sense of justice was offended. So I went through the matter. I presented my submissions, and the state tried very hard at that time to produce some IB extracts, and which I objected to because I quoted the 5-judge bench of Justice Sirimana. And then finally, even the judges were very keen on looking at it, but finally they relented because, of course, the 5-judge bench stood in the way, and they didn't allow it. And finally, he was acquitted. So the first accused, my client, was acquitted, but the second and third were convicted, and it was affirmed in appeal. Then the State Council showed me those extracts, and that showed that how he had spirited, that he had given this confession. He had taken this girl to the Hamilton Canal in Pamlugama, that area, and how he had strangled her, thrown the body into the water, and that actually he had thrown up after the incident, and then they had panicked because they took her for a ransom. And then finally, this was the evidence, and I was in a state of shock. Maybe I was immature. I was in a state of shock. Then what happened was the father. I can relate this story to you because it was something that happened in the early 90s. So the father, who was a pottery master at St. Thomas's Prep, came to see me with the mother. and they sent this boy to Australia and came and gave me a statue of justice, right? Which he himself had molded. And he said, "Thank you, sir. Justice has triumphed." A very, very dignified gentleman. But then I told him what I had discovered in those extracts. And then I had this statue of justice here to remind me of that. And my wife, who threatened me at that time, saying that I had done something wrong, and who continues to threaten me 25 years later in our marriage, right? She, who has been the countermanding force in my career, she told me, that is the end of your criminal law. So very reluctantly, because I was very interested in that field, reluctantly I gave that up. But whilst I was in the Court of Appeal and Supreme Court, when I was free, I meandered into various courts, and I strongly recommend young lawyers that when you're free, not when you're free, actually, you must make time to go to all the courts, from the district court to the magistrates court to the Court of Appeal, High Court, Supreme Court. Go and watch how the top counsel, choose for yourself who are the top counsel in those courts, and actually watch them making submissions, watch their strategies, see how they approach cases, see how they deal with their judge. So I watched, and I was absolutely taken aback with awe and being impressed with Mr. Faiz Mustafa, President's Counsel. Then I was very, very fortunate to have been able to become his junior. And I worked with him for about 10 years, I think, until he became High Commissioner of the UK. And the big break I got, but before that, let me tell you this. His chambers was full with very, very good lawyers. So all I did was, from the day I worked with him, I put my head down and worked. So if he gave me a draft saying, "Sanjeev, can I have this draft?" He didn't give me a deadline. The draft was on his desk the next day. I did it overnight. I must say, my wife used to sit with me. We didn't have proper computers at that time. She used to actually take it down, and we used to get it typed. And the next day, the draft was on the table. So that I showed absolute dedication, commitment. And for all you juniors out there, the main way to get seen and heard by your senior is for your senior to start relying on you for your maturity, relying on you for your work, and for your resourcefulness. So anyway, after he went abroad, he gave me 51 cases because he couldn't handle that because he was going abroad. He told me to argue it. So in the course of doing that, and Mr. Mustafa's briefs were, obviously, he was at the top of his game. He still is just touchwood on the top of his game, His briefs included actually opposing counsel who were top President's Counsel. And I will come to that later. Some of those President's Counsel after that, who I was opposed to by this default, as it were, and providence, started retaining me on a freelance basis as their juniors. So that was the big break I got. And I continued the passion that I showed in 1992, I hope, I have continued all the way up to 2021. And that is what I try to instill in my juniors daily, which they reciprocate that very, very positively. And I'll come to that. But before all that, so that's how I actually got to doing. So one more thing. Then I got so much of advice from various people saying, "This you're making a bad error. Don't start off in the Supreme Court. Don't start off in the Court of Appeal. Get your experience in the district court. If you're going to do civil, get your experience in the district court, and then work yourself slowly up to the Court of Appeal and Supreme Court." And I was actually discouraged by that advice. So I went and spoke to Dr. Mark Fernandez, who I knew very well, Justice Mark Fernandez, who I knew very well. And he said, "That's nonsense." He said, "Sanjeev, that's absolutely nonsense. So don't listen to that evidence. Don't listen to that advice. You will find with time that when you're actually in the Court of Appeal and Supreme Court, you will see things." Now, I say this with the greatest deference to all the trial lawyers who are there. They are in a very interesting and very vibrant field of law. But I'm just telling you, what I'm telling you, Janaka, is completely my experience, right? And it's my personal view. So he told me, you will see things that try in appeal. When studying your appellate brief, you will see the errors that were committed. You will see like a drone, on a macro basis, a ballpark figure of the errors that the judge committed. The way the issues were not framed properly, the way the evidence was not properly led, and especially critically, where the cross-examination was mismanaged. For instance, you see very often, I see when I'm studying my appeal briefs, right? I see a point where a cross-examining counsel gets his witness, right? He fixes his witness to the wall, right? And gets him to admit something and then asks that one last stupid question, right? Which puts that man on alert and he starts reversing what he said. So I have held my head often in appeal and told my juniors, I said, "Ayyo, me monada karaga," right? So that is one thing that, so anyway, Justice Fernando told me all this. And I see that on a daily basis when I'm actually studying my briefs. So anyway, this is what made me go there. Now, if I may give you a little bit of advice, these my colleagues, younger colleagues at the bar, right? A few rules that I stick by. Janaka, remember, item number 1, you are first and foremost an officer of court. There is no greater paramount duty than being an officer of court. What does that entail? You have to be totally candid with your judge. You cannot mislead or misdirect your judge. Number 3, all you young counsel out there, don't feel at any moment, even at a weak moment, don't feel encouraged to win your case by suppressing some facts, and especially a fact for which your client does not have justice on his side. That is the biggest advice I can give you, because you may want to win your cases, you may want to make a mark in the bar soon, but that's not going to cut it, right? Because as you mature, you will understand perhaps, if I may call it presumptuously, the wisdom with which I'm saying this. Because what happens is the judges start to trust you. Judges start to take your word, right? And the judges know that your word is your bond. So if you have weaknesses in your case, admit it. If the judge says, look, Mr. So-and-so, Mr. Javadan so-and-so, this is your weakness in your case, I say, yes, my lord. However, and then if you say, however, you are legitimately entitled to show the judge other factors which may inure to your benefit. But you can't misdirect the judge on that weak fact, right? So now your judges trust in you. Going forward is the greatest thing. Now I'm reminded, because I often, another thing these younger lawyers can do is, I often listen, because you can't get a video of the US Supreme Court. I listen often to the oral tapes of the Supreme Court, US Supreme Court, and how they handled lawyers. Of course, there's a problem there. Let me digress. The US Supreme Court, they don't allow lawyers to talk, nor do they allow their own judges to talk. And Justice Clarence Thomas, right? Because the problem is, Janaka, all the briefs are fully prepared, right? They read their briefs. Actually, the oral argument component of it is only 10%. So they are there not to let the lawyer make submissions, but actually get clarifications with regard to the brief that they have studied. So it becomes a very, very difficult task, because, I mean, those lawyers, they are brilliant. They're all Harvard, Yale, whatever, right? But they are subjugated. They are hammered by the judges. But at no point do I ever see a judge being rude. I can't say the same thing for other jurisdictions, right? However, what happens is, these lawyers, the judge doesn't raise his voice. The lawyer never raises his voice. The lawyer doesn't have to raise his voice because the judge doesn't raise his voice. Okay? And I have watched so many judges. I have just watched the interviews, like Justice Clarence Thomas, the Chief Justice Roberts, John J. Roberts, and Justice Souter, Breyer, Sotomayor, and you know the famous Ruth Bader Ginsburg, and Clarence Thomas. They have been asked by so many students, by so many law institutions, what is the type of counsel you think is a brilliant counsel? They say the counsel they look for is the honest, candid counsel. Because they say in 5 minutes, we can tell whether lawyer is lying or not, right? Number two, don't overstate your case. Be dispassionate. Now it's very, very, very difficult for us in Sri Lanka or in India for us to be dispassionate. I am guilty of all the things I have been telling over my career, all the things that I have been telling you not to do, right? But I guess I have worked out over the years how to deal with or how to suppress those, right? So therefore, the first thing they say in those interviews is be candid, be honest, admit if there's a weakness, but show us other ways, other approaches, other innovative methods by which we should be invited to approach your case. Now, second thing, do not annoy your judge. Do not make your judge angry. But I'm talking about a reasonable judge. Okay, I know there are enough and more unreasonable judges, but they are very much in the minority. 99.9 judges, 0.9% of the judges I have come across are reasonable. And it takes a lot to annoy them. It takes a lot to anger them. But if you do that, you are going to have a serious problem with their final decision making. Because you must remember, you are not like a surgeon who's, for instance, doing some surgery where there is no human agency or any element involved, or engineer who's building a bridge where there is no human. They are dealing with other forces. Here, you're dealing with the subjective view of 2 human beings or 3 human beings, be it the Supreme Court or the Court of Appeal. So it is the matter of the greatest and most paramount importance that you deal with your judge properly. Gain his trust, be honest with him, don't annoy him, and don't anger him. Speak to them directly, but I'm telling all juniors, do not bow and scrape before your judge. You don't need to do that. You are paid to do a job. The judge is paid to do a job to listen to you, right? So whilst you should be humble with your judge, very, very respectful with your judge. Do not unnecessarily bow and scrape before a judge, because it takes energy away from your case. I have seen too many counsel who actually do that. And I have seen too many counsel when in that 1% or 2% where judges are being utterly unreasonable, unfortunately, or even sometimes rude, where they have actually, the lawyers have basically succumbed and not presented their case properly because they are deflected from it. Now, the second principle I live by is Murphy's Law. Murphy's Law means that go on the basis, I think all successful lawyers all over the world practice that. Murphy's Law is that you go on the assumption that if anything can go wrong, it will go wrong. So basically, you may take preemptive measures in preparing your brief, in preparing your submissions. You first try to predict with prescience. You try to predict as to what arguments the other side will bring. And in that context, your most important part of your brief is your first consultation with your client. Your consultation with your client is the most rigorous test that you must put that person to, because often clients come and what they do is they think that they can get away by misleading your lawyer, right? Or the lawyer doesn't get to the bottom of the case either because he doesn't give adequate time for the consultation, or because he doesn't cross-examine his client. Now, I remember I worked with several of those counsel that I told you, and I watched all of them, Mr. H.L. De Silva, Mr. Choksi, Mr. E.D. Vikramanayaka, S.L. Gunasekara, and then Mr. R.K.W. Gunasekara. I used to go for consultations with him. I was like taken aback because the client would come and say, sir, this is the thing, or in Sinhala, sir, make a. He said, so what? So that was his view. So what? You tell me. Why should I take your case? Right? So that was the test that he put. And then as a result of which, if you cross-examine now, for my consultations, I normally go through the process of a minimum of half an hour or 1 hour. Because I always tell them, your biggest problem, your biggest test is not with the judges, your biggest test is with me. Because you have to first convince me. And then you find things that they would have never actually disclosed to you in the ordinary course. So then what happens is you're also able to prepare your brief that much better in logical progression. So all the documents you should produce are actually elicited. Those documents are produced in the brief. And then when the judges read your brief, you go in linear progression, logically, A to B, B to C, B to D. Never prepare your brief or make submissions where you start off by saying A to D to M to K, right? Because logic. Because remember, once again, there is a human being on the other side trying to understand you. So when you are trying to, when you don't present your case in logical progression to a logical mind, now you're looking at a Supreme Court, Court of Appeal, you're talking about the most mature legal minds in the country, right? So therefore, you need to present it in that way. And so what I try to do is, my documents which I present are also arranged in the brief in that way. And the other strategy I follow is that when I present a case, I give about 10 minutes, nothing more than 10 minutes of a brief overview on my feet at the bar table. And immediately I take the judges to the documents. So that when I examine the documents together with them, firstly, they get very interested. Secondly, when they come to the end of the case, what happens is they actually remember, it's all imprinted in their mind, right? So that is the next one. The other thing is, you will see that you must realize, juniors especially, if I were to apportion a case, if I take a spectrum, how much does the law count? How much does the facts count? How much does your judge count? How much do you matter, right? In my experience, I'm talking about the Supreme Court. Trial court may be different, Supreme Court. Generally, I would think 40% depends on the facts. 30 or 25% depends on the law. 20% depends on your judge. Because your judge may have, all human beings, and naturally, they may have personal philosophies, they may have personal proclivities, they may have strong views. Now, if you take the US, if you take that famous debate between Justice Anthony Scalia and Ruth Bader Ginsburg, when it came to constitutional matters, they took wildly varying views, because Justice Scalia said he was an originalist. He was a person who said that the Constitution must be interpreted according to what the founding fathers did, what their intention was in 1787, which is 21 years ago, right? But Justice Bader was basically a pragmatist, and she was an organist in the sense that she said the Constitution is a living, organic document, and therefore you must adjust the Constitution depending on the contemporary context. So those wildly varying views. Now imagine if you came up before one of those two judges who had those personal philosophies, right? Your case, the success of your case would differ. So 30% to the law, 40% for the facts, 20% to the judge, and your influence on the case as a counsel of capacity is only 10%. In the Supreme Court, the Court of Appeal. But that 10% matters a lot, right? So you master your law, you master your facts, you have no control over the judge's philosophy. It's called the inarticulate major premise or the X factor. That's a variable, that's a subjective. And of course, you ensure, so what you have to ensure as a good lawyer is this. You have to ensure that you have complete mastery of your brief, so that if a judge asks you a question, you have the answer. Now, Mr. Arthur Samarasekara, who I worked with, was the most exceptional lawyer I have ever seen in that way. He knew his brief from A to Z and Z to A. Even a small postal article receipt in a partition matter or anything, he would read, right? So he was never caught out. Then your mastery over the law. Then what do you do when you make oral? Bear with me, Janaka, for a few more minutes. Is that okay?
That's fine. So I don't want to stop you. You can go about another 3 minutes.
Yeah, Lakmini is coming and gesticulating to me wildly, telling me to stop. Okay. Okay, right. Yeah. So I'm making oral submissions, right?
Your key juniors.
I know. So oral submission. So I told you the main thing is strict sequential progression, right? So there is logic. Second thing is, remember, cases are often lost in the first 15 minutes, won or lost. So what did Justice Kalia also say? If you tell the court, I have 5 points, my lord, you must start off elucidating your case. After those, identifying those 5 points with your strongest point. Go back, repeating it with frequency and din it into your judge's head. That is your case. That is your trump card, right? Then the other thing is, remember, spend adequate time in your submissions analyzing the respondent's pleadings, because the judge will, after he looks up, when he listens to your case, he will now analyze what exactly the respondents are saying. So if you can, bear me the phrase, you must rip your opponent's pleadings to shreds, if you can. If your client's, of course, if your client's case demands that justice, right? And then Justice Mark Fernandez gave me another bit of advice. He said the most important pleading in any case in the appellate forum is your count affidavit. Often I see count affidavits of many counsel are just 1 page, 2 pages, 3 pages. No, you clinch your case in your count affidavit. So you must, in you're making your submissions, you must dwell enough adequately on the respondent's pleadings and then the counter affidavit. Then in your language skills should be clear. There should be clarity. It must be unambiguous, and your point must come across with force. Now, again, I'm sorry to quote Justice Kalia so much, but I'm very, very much a fan of his. He said that the principal tool of communication is language, and optimize that tool of communication by bringing the most descriptive word in the English language for communicating your idea. Right. Next one. Study your judge at all times. Now, all I don't know whether any learned honorable judges are looking at this, but they probably know what I do. I am always looking at my judge, because I'm always looking to see whether the learned judge shows confusion. Has he understood my case? Does he think that I am not being clear? Right? Is he angry? Am I annoying him? Am I making him angry? So what I do is, sometimes when I see that a judge looks confused or that I have not driven my point home properly, what I do is I say, is there any matter on which I can clarify? Does your lordship want any clarification on this matter? And I pause. So sometimes they say, no, carry on, Mr. Jayawardhan, or they say, yes, in fact, now, Mr. Jayawardhan, I want to ask you this. So do not wait for that question to be festering in the judge's mind. Clarify then and move on, right? So that is also very important. And I see too many lawyers, Janaka, annoying the judge, upsetting the judge, and they don't even realize. They don't even realize because they're not looking at the judge. Even when the judges are conferring, 2 judges, 3 judges are discussing, the lawyer is still making submissions. That's not advocacy. So people have to be taught, right? So, and also, if you are before 3 judges of the Supreme Court or a divisional bench of 7 judges, speak to direct your submissions to each and every one of them. Look at them. Of course, often, I can't be charged for contempt here, I think. Often it's the head judge who will direct the proceedings. He or she steers the course. I don't know by whether it's by sheer force of personality or seniority, but that happens. But equally often, there are judges, the other 2 judges dissent. So direct your submissions, interact with them, have a human rapport with the judges, and make them interested. Some judges fall asleep. I remember in the 90s, 3 judges of the Supreme Court, there was a Chief Justice, and they got up, adjourned the case, and one Supreme Court judge was asleep. So the Chief Justice came running back and shook him and took him off. So maybe the lawyer put him to sleep, right? So what I'm trying to say is, I won't say anything else. The lawyer would have put them to sleep. So make your submissions interesting, and remember, they are human beings. Last few things. With your opponent, remember, never be unfair by your opponent. Always respect your opponent, right? And never humiliate him. Actually, never humiliate your judge, and never humiliate your opponent. And never get into, I'm sorry for being so prescriptive rather than being instructive, right? Don't ever get into verbal duels and fisticuffs, verbal fisticuffs with your opponent for 2 reasons. One is, in the appellate courts, the judges don't like it. They don't take kindly to it. They don't think because you shout down your opponent, you're being smart, or that you're smart, right? They think it's undermining the decorum of court. That's the first issue. Second issue is that when you get into a fight with your opposing counsel, remember, you are being thrown off balance from the directionality of your case, the focus of your case. I know there were 2 or 3 president's counsel who I had seen in the past who were very emotional. So the first thing that the other counsel does is, he says something to annoy that person. Then he goes into a tirade and forgets about his case. So do not let either a judge or your opponent ever throw you off focus from your case. So the only way to deal with a rude and aggressive opponent is to very impliedly be sarcastic, use your wit, use your humor, and your power of repartee, and do it with class, and do it with sophistication, right? Then, yeah, I'm done. I understand.
I'm so sorry to
No.
at that point, but
I'm
so
glad
it was a very interesting and thought-provoking session.
Right,
Speech.
no problem. Thank you very much for listening to me. Yeah, thanks.
Thank you very much for that, sir. With that, ladies and gentlemen, we have our next speaker, Mrs. Noorani Amarasinghe. She's an experienced counsel with long years of practice in the courts of first instance, especially in the district courts. Mrs. Noorani Amarasinghe will speak to you about a counsel's role in the courts of first instance and challenges faced by lady lawyers. Over to you, madam. I think you have to unmute yourself, Ms. Amarasinghe. You're being muted. Yes.
Thank you, Janaka. First of all, let me thank the BASL and the Profession and Career Development of Women Lawyers Committee for having invited me to be part of this webinar. The role of a counsel, as Mr. Jayawardena said, is to assist court in dispensing justice. Becoming a counsel is very challenging. And if you are a lady counsel, it is, I would say, doubly challenging. it is even more challenging to become a counsel in the original court. Why do I say so? It is where you try your case initially. You call your witnesses, you lead evidence, you cross-examine, re-examine, various orders are being made, objections are raised, submissions are made, counter-submissions are made, incidental orders will be made, and interim applications will be made. So all these happenings, activities, spontaneous or otherwise, take place in the original court. As you know, a case will not come to an end in the district court itself. Most of the cases end up in the appellate court. Now, Mr. Jayawardena mentioned that sometimes when he goes through briefs, when he sees the cross-examination, he comes into a shock. To make an appeal sustainable, the case in the original court should have been handled in the proper manner, and I would say a solid foundation should have been laid in the original court.
Nurani, I'm sorry to disturb you, just to assist you on one thing, not only on the cross-examination, but also in the articulation of the issues, where they don't go into the proper issue of the case. Yeah.
So before it comes to appearing in court, I say there's a lot of spade work to be done in your chamber. When you have the consultations, as Mr. Jayawardena said, you must get the important instructions. You must see whether the client is coming out with the truth. Do not go by only what the client says. Actually, you have to cross-examine the client and get all the relevant vital information. You have to spend a fair amount of time with your client. You know, sometimes the clients come with a long harangue. You may not have all the time to be listening to him, but especially in divorce cases and things like that, it is better for you to get instructions in writing so that there won't be any misunderstanding. The client can't find fault with you that you have been told and that has not been incorporated. So it is up to you to have a proper consultation and get correct and all important information and instruction. Then when it comes to documents, the client may come only with the documents that he is possessed of. Now, for instance, for a partition case, the client may come with his title deed. Is that enough to file a partition action? No. You have to do an investigation. You have to get the title search done with the assistance of the instructing attorney. Then you have to draw up of the pedigrees and read every deed, because that is what my guru has taught me. No shortcuts. Read, and read. Some, you come across certain deeds, they may be illegible. Still, you must make an attempt and read and grasp and analyze those documents, because you don't go by only what your client says. And you may have your memory power, but it is always good for you to make your notes. For a partition case, sometimes you may have a long pedigree. You can't remember the number of the deeds, dates, names of the notaries. So it is always better for you to have your notes. Now, in certain cases, there may be digital evidence, electronic evidence, SMS messages. Like in a divorce case, then you must tell your client, okay, protect these evidence. Sometimes they may be in your phone, on your phone. You must tell your client to protect those, because by the time you need them, they may be not there. So that your guidance as a counsel is very, very important. Even when you are obtaining documents, the clients sometimes don't know from where to obtain these documents. Then you must tell them from where to obtain these documents and how you should obtain these documents. At the same time, when the client comes to you, some clients sleep over their rights. you must see whether the action is alive, whether it is prescribed. If it is prescribed, even if you see that on the face of it that your action is prescribed, still I would advise you to study properly and see whether there's anything that you can revive the case. There are instances where I have seen important points and I have filed action. Of course, at one stage I discouraged my client, but the client insisted. I gave it a try and I succeeded. And also there may be prerequisites before filing action. Like we'll say if the client comes saying that there's a house and the person living there has come into possession with your leave-in license, then firstly, you have to terminate leave-in license. Likewise, if it's a lease agreement, maybe that you have to terminate the lease agreement. If it is a defamation case, maybe you have to demand damages be paid, or if you are demanding a correction of a statement, a defamatory statement or whatever, then you can demand. So those have to be attended to. A good counsel will, without wasting time, will look into those things. When you study all the documents, then it comes to the drafting. When you are doing your drafting, you have to be thorough as to what kind of an action has to be filed, whether it is under regular procedure, summary procedure, or whether if it is, I mean, there are certain laws that you have to plead, under what law you have to come to court, what sections have to be pleaded in the pleadings. You have to be very clear in your strategy. And you have to know now if it is an answer, whether it is an answer that you have to file, whether it is objections, whether it is show cause, or whether you have to seek leave in your application, and whether it is petition and affidavit, or whether it is plaint and affidavit, answer and affidavit. You have to decide what type of papers you have to file. For that, you have to read the relevant sections. You have to understand the law, and then only you should start your drafting. Sometimes the client may not know that what kind of relief he can get. Sometimes maybe that you have to get an injunction or an interim order. You must advise the client, and in such an event, if you have to get the client to make a police entry, you must advise your client to go and make these entries. Otherwise, you are just wasting time. By the time, then you are too late to come to court. And also it is important to be frank with your client. If you feel that the client has no case, you must tell the client that you don't stand a chance. If it is 50-50, please tell that to the client, because then client will not have high hopes. Sometimes even if you stand a very small chance, still he may want to give it a try. Then it is a different matter. And also be frank with the client. Don't overcharge, be reasonable, and indicate that maybe that you have to be ready with so much of money for appearance, for drafting of papers. Just give an idea so that they know, not that everybody is well enough to pay you whatever the fees you demand. And it is my practice that when I draft some papers, I always give the draft to the client for them to peruse it, for the reason, if he's in a position to understand his case, he will go through it and he will make his comments. And if you, by any chance, if you have made any mistakes with regard to dates or vital incidents, he may come and tell you. So that is also a good thing to do. And of course, sometimes you find clients who actually do not know what their case is. You have to tell him what their case is. I have seen several instances where when it is there's a case where I was retained in the appeal, and in the appeal I lost the appeal. Why? Because the plaintiff, that case being a partition case, the plaintiff has not said anything about his title, extent he was entitled to, the boundaries, nothing. Every question he has said, Mama Danne, or he has kept quiet. I was so sad that if only the council had just spent, if he has had spent some time with this client and guided him what to give, how to give evidence, and what to say in his evidence, this wouldn't have happened. He actually had a very good case, but he lost because of his evidence. I'm not for a moment saying that you should come to courts and lie. By guiding the client, what you have to say is, you have to say that this is what is required to prove your case. These are the documents. You always must choose the best evidence and the best witnesses. In a partition case, we'll assume that the plaintiff is a mother. He is 80 odd years old. But if a son knows the history and the pedigree, you can, instead of the mother, call the son. It will be far easier to have a person who understands, who hears properly, and who can speak to the facts from his personal knowledge. So always it is your duty to choose the correct witness, and also you have to choose the best evidence. You must always instruct the client to get the best evidence. Sometimes the clients come and say, okay, we have so many witnesses, but none of them may be wanting to come and give evidence. So how are you going to prove your case? Therefore, it is at the very beginning, I say that you have to have your strategy. Sometimes maybe that you have to deviate from your strategy. Then of course you have to go with the tide. Still, if you are conversant with the facts and if you are conversant with the law, you will find your way out. Then when drafting part is done, you should know that there's this pre-trial stage and trial stage. If it is pre-trial, you have to file the papers, you have to draft the issues, you have to file the list of witnesses and documents well in advance. Don't wait for the last minute. In the list of witnesses and documents, I have come across many cases where we have had issues because sometimes this had been done by the instructing attorney. Counsel has not guided the instructing attorney as to what needed be listed. Important documents had not been listed. Then you have to face various objections at the time you try to mark a document or call an evidence. Ultimately, due to your mistake, ultimately the poor client has to face the music. So it is always better to act with responsibility, recognize your responsibility and do it. In some cases, maybe that it is necessary to file interrogatories, maybe that it is necessary to move for commissions. You have to advise your client. Now, if there's an encroachment, how are you going to do it without getting a commission? You have to identify the portion that has been encroached upon. So you have to have a commission. You have to instruct your client. Maybe you are challenging a deed, then you have to get a commission from equity. Then you have to advise that you have to have signatures, reliable signatures, which cannot be challenged. All those, it is your responsibility as a counsel. So I wish to tell all the young lawyers, young counsel, it is good. It is a must that you recognize your responsibility and act with due diligence. Because with your mistake, don't leave room for your poor client to suffer. And as I said, before you call witnesses, have a consultation and just tell them this is what is expected. It is not you are training him to come to court and lie, but tell him to come out with the truth. Sometimes the clients don't know what to say. You must inform the client this is what is expected. And then they will get an idea as to what is required to be stated in court. With regard to the documents, with regard to the incidents, you have to check and put the best witness. You don't have to call 10, 20 witnesses. If you decide the very important witnesses to be called, because that will save some money for the client, save time of court, and you are not making the case record big. All that matters. So you have to be very careful in choosing your witnesses and documents. Then when it comes to the appearance in court, then only this court craft comes into play. Firstly, I would say, especially to the lady lawyers, be properly attired. I was told by my guru, when you are seen in court, when a person sees you, that person must get the idea that you are a lawyer. There was an incident once in Mount Lebanon when I was 5 years after I joined the bar. There was this court sergeant who came rushing and asked the lawyer to get up from her seat to see she was a lawyer. But actually, even the court sergeant couldn't recognize her to be a lawyer because of her attire. Sorry to say, but it was a situation. And that adds to your personality. When you are properly attired, you are confident. Then the other thing is, you have to know in and out of your case. As Mrs. Jayawardena said, I have also read Ms. Arthur Samalsekara's article. He says to read over and over again. Then what you have missed in the first instance, you will realize that you have missed, and you will gather more and more information when you are reading it for the second time. If you are ready with your case, you are fully geared. And if you know what is the law applicable, there's nothing for you to worry. And this court craft, I personally feel it is something in you. It comes instinctively. And it comes by watching other senior renowned counsel. You learn a lot. And if you are lucky to be under a senior, you have a tremendous advantage of learning fast, because you see the senior handling the case, the way senior handles the cases, how he conducts the cases, how he leads evidence, how he cross-examines. And it is a very important fact that you do not over cross-examine a witness. I have seen the lawyers messing up a lot of cases, because when you come to a point, you are very happy that he has come out with certain answers, so you go over and over and cross-examine. Then, as Mr. Jayawardena said, then the witness is geared to come out with another story. Don't leave room for that. And once I say that when you are a counsel, you have to be very vigilant, smart, attentive, and cunning. It doesn't mean that you have to lie to court, but always you have to maintain your integrity. You have to be truthful, but it doesn't mean that you have to divulge everything. And you have to know when to say and what to say. You have to be very patient. You don't play your trump cards at once. Wait for the correct time and then play your card. You have to have a good temperament, as Mr. Jayawardena said. You know, even in the original court, when you are leading, there are several cases a day. When you are leading evidence or cross-examining or addressing, you shouldn't make the judge angry. It doesn't mean that you have to give in to him, but you have to stick to your submission, but be respectful and be polite. I personally feel as time goes on, you acquire certain reputation, because judges get to know you. They know that if this is the person, well, he will not come and say a lie, or she will not come and say a lie. Because I have experienced it. Whenever I have not been ready in a case, when I have had a problem, I have always mentioned to the judge, look here, I have had this issue. Please grant me a date. I'm not ready in the matter. You say it openly without going around the bush. I have always managed to get a date without any problem. I think that is the trust that you have to build up, that you can do only by proving yourself. When you conduct yourself properly, that you automatically acquire. Sometimes when you are a lady lawyer.
Mrs. Amarsinha, I'm really sorry to barge in at this point of time, but we are working on a tight schedule. I might have to cut off, ask you to stop at that point.
Yeah.
Maybe we can take it, we can explain further in the question and answer session. Thank you very much for your practical experiences sharing with us, especially for young counsel who are aspiring lady counsel to improve their skills. Thanks a lot. Next, we have, dear participants, we have a well-articulate, versatile practitioner, Mr. Mohammed Adamali, attorney at law. I'm extra careful in his presence in my pronunciation and language, as he is a master of all his oratorical skills and language. He is also a renowned actor and a trainer, most of all a courteous lawyer and an admirable opponent. With that in mind, Mr. Adamali will lead us through the characteristics of effective lawyering and maintaining decorum within the courtroom. Over to you, sir.
Thank you, Janaka. Thank you for your very kind words, and to Compia as well for his introduction and to the Bar Association. As King Henry said to his wives, I promise I will not keep you long. Ladies and gentlemen, thank you for being with us. Much has already been covered, and so I'll change strategy a little and try and look at some areas that haven't been addressed, and thought I'll leave you with some thoughts about what good advocacy might be, so that perhaps we can explore it further during questions. So this topic of what makes a good advocate, or what is involved with good advocacy, is something that has been discussed and written on for decades in all jurisdictions. And initially it was believed that the skill and the talent of advocacy was something that you were born with. It was an inherent skill. You were a born advocate, and that advocates were not made. Because it was thought that the two essential skill requirements of advocacy, that of a sharp intellect, was a congenital skill. It was a gift, rather, something that you was in your genes, you were born with. And that matching that sharp intellect with the ability to express intellectual thoughts orally, with clarity, with conviction, with simplicity, was also a talent. But now, of course, we've come to accept the fact that good advocacy can in fact be learned. And that while there are some things that might be stamps of nature, so to speak, which lend itself to certain advantages in your advocacy, things like, say, a stature, a physical presence that commands attention, perhaps, or a voice that is, let me put it in this way, a voice that is not displeasing to the ear, or I'm trying to be diplomatic here, or the ability to think fast on your feet. While those might be stamps of nature, we can still overcome the lack of them with other skills that can still produce a really great advocate. So what is effective advocacy then? If you read some of the work written, I think 30, 40 years ago by people like Gibbs in his work, Appellate Advocacy, or Mason, they tend to agree that the primary talent of a good advocate is his ability to reduce a complex matter into bare essentials. How would you do that? You think them through. You think through the essentials, the elements that are necessary for the taking of the decision. The elements that are necessary for the taking of the decision, the way you want it taken. And then presenting to the decision maker those elements as attractively as possible and with precision. So it's not just a flurry of words, and sometimes we see eminent counsel getting carried away in colorful language, in side issues. It is a case of actually being precise, and as I think Sanjiva put it, finding the right words that will describe your point accurately. I want to read for you a little passage in a speech given by the Honorable Justice Michael Kirby, who was the President of the Court of Appeal of New South Wales, when he was addressing the Advocacy Institute in Australia, way back, I think, maybe 25 years ago. There's a particular passage that I want to read because it raises some of these thoughts of what is required for good advocacy. And he says, the object of advocacy is not, and I am reading from his speech, the object of advocacy is not ultimately to please the ego of the advocate, nor is it in the end functionally directed at impressing and instructing solicitor, a colleague, the opponent, important though that might be for professional success. Right? So impressing your colleagues or your solicitor might be important for professional success, but as he says, nor is it in the end functionally directed at impressing the instructing attorney, your colleagues or opponents. It is not even satisfying the client, win or lose, that the case has been put with appropriate command of the facts, a good grasp of the law, and as persuasively as the facts and law permit. In the end, the object of advocacy is, by communication, to persuade. It is to influence the decision maker to accept the propositions advanced by the advocate, leading to the success of the advocate's cause. So the end goal then is persuasion. Now, does that mean, and I unquote, that was some of the quotation, does that mean that persuasion in any means possible, with no guidelines, no rules? You use whatever is available at hand at the moment to win? No, that's not how it works, clearly. I think there's no confusion on that. Firstly, persuasion has to be within the framework of the law. To submit something that is legally ridiculous, that defies the principles of law, might be going a little far. Of course, we can push the boundaries, and we do push the boundaries. We expand the law through good advocacy. We get judges to go beyond the obvious principle, create exceptions, etc. And that, of course, is permitted. And that, of course, is part of great advocacy. What are the other things that guide us or restrict us in this drive for persuasion? The law is a noble profession. Ethics and good practice, of course, have to stand tall. We do not push this boundary. We push the boundary of the written law to expand it, but we don't push the ethics and good practice boundary. We stay within it. Ethical conduct vis-a-vis yourself, you need to be conscious of the fact that you have complied. ethics vis-a-vis your client, ethics vis-a-vis the court, ethics vis-a-vis the witness that you might be cross-examining. Right? I've seen counsel being extremely rude to their own witness when their own witness does not give them the answer that they have prepared for. First, the question of whether that answer should have been prepared or not is an ethical question. But having done that, when the answer does not come, you find counsel being positively rude at their witness, rude at opposing witnesses. These are officers of court. Right? When they stand in the witness box, they're an officer of court. Ethics vis-a-vis your opposing counsel, attempting to fiddle with documents, etc., not providing documents or copies thereof to opposing counsel in a trial matter so that the counsel is not able to prepare. Those are all tactics which we don't really need to do in this journey of persuasion. Sanjeev, in fact, brought up this point, which I thought was extremely important, especially to the young lawyers that we have on this forum, and that was that we have a higher duty to the court. And I actually want to again cite something from this. When you were speaking about it, I fished out something that I had read earlier. And that is, I've got it here with me. It's from Rondell versus Worsley. Now, this case was particularly important because, and I'm recalling the facts because it's been a while since I was familiar with the judgment. It was important because it dealt with this question of whether a lawyer could be sued by his client for negligence in the conduct of his case in the courtroom, in urging a particular point which ought not to have been urged, or not urging a point that he ought to have taken up in the course of his argument. And Lord Denning held very firmly that lawyers, if I recall right, there would be no action that would lie against the lawyer for that. Of course, this judgment was overruled 30 or 40 years later, 30 or 35 years later, I think, by the courts in the UK, and they held that, that within certain guidelines, a lawyer could be sued for how he chooses to manage his case in the courtroom. Lord Denning had this to say, and I think these words are really important for us to remember. He said, as an advocate, he is a minister of justice equally with the judge. A minister of justice equally with the judge. He has a duty to the court which is paramount. It is a mistake to suppose that he is the mouthpiece of his client to say what he wants, or his tool to do what he directs. I've sat with Mr. Javad and I had several consultations, and he is quick to tell his client that if you want this to be done, please go to someone else. Denning continues, he is none of these things. He owes allegiance to a higher cause. It is the cause of truth and justice. So this is an important fundamental guideline for any advocate. And as was pointed out earlier, following this guideline is what builds your trust in the court, builds the confidence of the court in you, to be able to take your word for it, even if you were to say that it is there in this document without even referring the document, the court might take your word for it if you have that standing with the judge. So what is the role of the judge in the advocacy of the lawyer? I thought that's something that we should talk a little about, because advocacy and the skill of advocacy is not only the doing of the lawyer, of the counsel. It is also contributed to a lot by the bench. There there is authority actually, that judicial open-mindedness and the willingness to attend to an argument are both the assumption and the requirement of a legal system. A judge being open-minded and willing to attend to an argument is a requirement of the legal system. Because if he is not, then there is no room for the growth of advocacy skills in his courtroom. If he comes to the bench with a fixed mind and is not willing to be swayed from that, the judge is not willing to listen to an argument unreasonably. You can certainly forgive him if the argument has no merit. But if he is not willing to listen to it unreasonably, then there is no room for the growth of advocacy. And why I say this is that I find sometimes that the bench can be a little dismissive, especially of junior lawyers. And if that is the case, and those conditions may not be frequent, but if that is the case, then I think the local bar has the duty to take these matters up with the bench in discussions, in looking at how the skills of advocacy can be fostered within that bar, and how lawyers can be given the opportunity to grow and advance these skills in the courtroom. It's important for the judge, I think, to speak his mind, at least in terms of clarifying doubts that he has. Sometimes the bench tends to feel that their duty is not to give any signs or signals. And you find, occasionally a judgment that might be written, and thankfully it is only occasional, where the judgment proceeds on some point and cites authorities which is never taken up in the case. The point was never urged. The point is not even valid on the facts. And that has been the basis on which the judgment has been given. Now, if that is going to be how the judgment is written, then what scope is there for advocacy? If the judge has predetermined the matter, does not seek clarification from you, does not respond, does not show whether he's understood the argument or not, then how do you know when to stop, for instance? If you don't have that kind of interaction, because at the end of the day, the court is seeking the truth and justice. And as I read earlier, I cited earlier, we are both partners equally in this higher cause. And so there has to be some interaction between them for advocacy to grow. A judge needs to manage his court. You find sometimes, a tendency of counsel to bulldoze their way through, to use volume rather than merit of argument, to try and shout down the opposing counsel or try and gain the attention of the judge. So that's not really necessary. It might be required if there is a travesty of justice happening in the courtroom, but that should not be the trend. And so if that is being resorted to as a means of persuasion, as a means of convincing, then it's perhaps important for the judge to manage the courtroom and say, volume is not needed. Side battles between counsel, Mr. Javadan already mentioned that, don't get dragged into it and don't practice it. It's, a bit of fun between counsel on the side in terms of a personal remark in jest, taken in that spirit and responded to in that spirit is always permitted, because it keeps the atmosphere of the court light and we enjoy our practice a little more. But, comments of that nature designed to be malicious or vicious are best avoided. And court needs to control that. Interruptions and interjections by counsel when counsel is in full thrust, again, need to be controlled. The bullying of a witness who is in the box, the abusing of the right of privileged speech, that's something we sometimes see. If the same statement were made by the lawyer outside the courtroom, it would be a cause of action for defamation. They will use the protection of the courtroom to make statements which are not in order. And the judge's paramount duty to create a level playing field. I remember this one incident, and again, it relates to Mr. Mustafa, so I will share it with you. I was in the early years of my practice, this was about 21 years ago, probably. I was opposed to him in the Court of Appeal. I was fortunate, or in that case, unfortunate, to be opposed to him in the Court of Appeal before Justice Nihal Jai Singh, I remember. And Justice Nihal Jai Singh was presiding on the bench, and I don't recall who the second judge was. Mr. Mustafa was in all his glory. He was in full flow that day. And, when he's in full flow, when he's at half flow, he's a treat to watch. Unless, of course, you're on the opposing side, when it's not that comfortable to be watching him in full flow. He addressed court for about 40 minutes in absolute full flow. And at the end of that 40 minutes, my client, was the interested party who, in a writ matter, responded. My client was clearly made out to be the scum of the earth. And I sat there wondering, how do I get up and even try and change the mind of the court after that? Justice Jai Singh, seeing my predicament and seeing that I was perhaps too junior in years to be able to take that onslaught, said, Ms. Adamali, I think we shall wait for the storm that Mr. Mustafa has brought into this court to subside before we hear you. I jumped to my feet and said, that's a very good idea, a very good suggestion. And I jumped to take a date to address court when the impact of that onslaught would be less prevalent on the judges. So that's again, a very interesting way in which the court can promote advocacy amongst the counsel. Right? Because certainly at that stage, in that particular case, I would not have been able to realize my fullest on that day. So then what are the essentials of good advocacy? I thought I'll quickly summarize them in my own words. I thought I'll break it up into 5 points. Know the facts. We've already dealt with that. I think Noorani handled that area also very well, and so did Mr. Jayawardena. Know the facts. So conceptualize your case from the beginning. We find very often counsel learning about their case along the way, attempting to bring up points along the way because they are not familiar with it fully at the beginning. I think you need to be thorough with it before you even draft papers, so that you know exactly what the boundaries of that case will be and what the arguments in that case are going to be, and not have to discover them along the way. Know the facts, know the law. Substance over elegance. While presentation, glamorously might be attractive, it is no substitute for substance. So substance over elegance. When you're citing authority, be careful about how you cite it. Careful not to mislead. We've seen far too often counsel who will cite one paragraph which is in their favor and suppress the next 3 paragraphs, or sometimes the next part of the sentence which goes against them. Not in order. Know the law. Know the policy of the law, the principle of the law, especially if you want court to expand the law, then know the policy of the law, what is behind the law, so that you can encourage the court to hold up that policy and expand the principle. Know the court, the third point. Know the court. The judge you're before. What is his expectation of counsel? Is he a judge that wants counsel to be brief and really to the point? Is it a judge who's already familiar with the facts so that you don't need to really labor them too much? What is the judge's point of view? This was also discussed by Sanjay. I remember there was this argument before Justice Shirani Bandaranaike. She had just a week or 2 weeks prior to my matter being taken up for argument, delivered a judgment on the same principle with regard to the Supreme Court rules. And her judgment had been fairly emphatic. I was coming up opposed to a fairly senior counsel in her court. And what I decided to do was, I thought I'll deal with that straight away. So as I got onto my feet, I said, Your Ladyship has delivered a judgment on this particular rule and on this particular point just 2 weeks ago, and that judgment is against me. I thought I'll start with that rather than wait for it to be later, taken up later. So she immediately said, yes, I have. And doesn't that judgment apply? Do we need to go into this again? I immediately said, it is, but in that judgment, the circumstances were such that the particular matter that I'm urging before Your Ladyship's court at this time is not covered by the reasoning that Your Ladyship has gone into. And that raised her curiosity on the matter. And it gave me the opening to go into it. And finally, she held in my favor on that matter. So, know the court, know what the judge would be thinking. And if that judge already has a view on a particular matter, know it so that you can deal with it at the beginning. Watch the bench, listen to the bench. There was a very disheartening incident I believe it was a labor tribunal, I think, many years ago, where a young lawyer was going on a particular line of cross-examination, and the judge was clearly, he had caught the point, he had had enough, and he was cautioning the young lawyer. The young lawyer was not listening to him and decided to proceed on his route. Seated opposite him at the bar table, or seated next to him rather at the bar table, was a former president actually of the Bar Association, who tapped the young man and said, young man, don't go on this basis, do this instead. And he very rudely, I probably did not know who the counsel was next to him, but he would have obviously seen that he was much senior to him. Very rudely, he said, you let me handle my case, don't interfere. And went on. And the judge, having actually seen and heard this incident, decided then to let the young lawyer have it. And he, the case was as good as lost, because you had effectively placed the judge on the other side by your conduct, by your failure to listen to the bench. I can't remember who it was who used this phrase. It was in one of the written things. One of these things about knowing the court is courage under fire. Be courageous under fire, because it is the court's right to strike at your argument and to try and find holes in it. Have the courage and the conviction to stand by it. So the points: know your facts, know the law, know the court, know how you will present. Be prepared with your opening. Be prepared with the structure of your examination in chief, if it's an original court. Be prepared with the structure of your cross-examination. Of course, that's not a script that you can always hold on to. Right? Especially in a trial court, you might need to shift direction depending on how the witness responds. You can be taken unawares. You can have an unexpected answer coming in. Even in an argument before the Superior Court, there might be a point brought up which you did not anticipate. You should have anticipated it as a characteristic of good advocacy, but if you didn't, then you should be prepared to change your structure and flow, but you should have your structure with you. Know your weaknesses, know your strengths. Have your self-confidence, not arrogance, but have your self-confidence, right? And be courteous to the court. Right? You can even tell off a judge in a very courteous manner so that it doesn't really appear to be rude, but you get your message across. So Once again, know your facts, know the law, know the court, know how you will present, and know the rules. Honesty at all times. Know your ethical boundaries. Know what lines you cannot cross. And I think you'll be on the road to good advocacy. I think I'm just going to round up at that point. I hope I haven't overstepped time.
Not at all, sir.
Right. Let's just keep it there. Oh, there's something else that I would like to just read to you before I let you go. In fact, for those of you who have a thrill by advocacy, I think you'll find a lot of meaning in this. I cited him earlier, Justice Michael Kirby from Australia. And he says this in the course of his address. He says, in the troughs of despair over an argument poorly executed or questions poorly answered may be found the profound melancholy of public and private humiliation. Right? In the troughs of despair over an argument poorly executed or questions poorly answered may be found the profound melancholy of public and private humiliation. If you've fared badly in court, you can feel really, really down. There might be public humiliation and certainly private humiliation to yourself because you know you didn't do the job well. He continues, but in bending the mind of another human being with power of legal decision to arguments successfully addressed, which turn the tide and lead to forensic triumph, there can be few moments of human activity so rewarding. Certainly, there are few occasions that offer such excitement. That is why the skills of the advocates must be sharpened and improved to avoid the moments of despair, to multiply the moments of deserved exhilaration. I think you would all agree that there is really no thrill like the thrill you get on that platform in the court. And while it can really bring you down, it can also really raise you up. And so the idea of good advocacy is to try and have those good moments, those positive moments more often, and the negative ones less often. Thank you.
Thank you, sir. Thank you indeed for that mind-boggling piece of presentation. I think all these speeches should be reduced in writing. These are all scholarly, and you all have spent a lot of time and energy in putting it through to all our young viewers, attorneys at law from Sri Lanka. Thank you again. Last but not the least, our final panelist for tonight, ladies and gentlemen, is Mr. Varuna Senadira, attorney at law. He is well-versed and experienced in the areas of banking, commercial, and financial law. He is a much sought-after senior practitioner for his holistic and scholarly approach for any given legal matter. Today, Mr. Senadira will address us on the professional duties, ethics, and playing the game within the rules, taking into consideration the relevant rules, codes of conduct, and judicial authorities pertaining to lawyers. I must also mention that Mr. Senadira was generous enough to prepare a comprehensive note encapsulating both aspects, all these aspects which directly affects the lawyers in discharging their professional duties. This handout will be shared with you via email, I was told by the BASL. So without much ado, let me now invite Mr. Senadira to address the participants. Over to you, sir.
Thank you, Janaka. Thank you, Joshua, for the nice word of introduction. And I warmly welcome all those of you who are joining with us through Zoom and YouTube. As you are aware, the area I'll be discussing with you relates to the legal profession and the code of conduct and the rules and regulation applicable to the legal profession. As you are aware, we belong to a distinguished profession of which the history goes back to 1801 in Sri Lanka. That is, with the enactment of the Royal Charter of Justice of 1801. As you are further aware, day by day, numbers joining the legal profession keeps tremendously increasing. And in this background, the need to uphold and maintain high standard of conduct amongst the lawyers has been felt more than ever before. Members of the general public normally has a great amount of trust and confidence on the office of an attorney at law. In that background, when the profession becomes increased day by day, there are many chances for the members of the profession to misuse the office of the attorney at law. In order to maintain a high standard of professional conduct in the legal profession, it is important that all members of the profession be well aware of the provisions of law and the guidelines that are applicable to lawyers, more specifically, the Supreme Court rules that regulates the conduct and the etiquette of lawyers in order to maintain a high standard of conduct, which is the ultimate objective of these rules. Now, since there is a restraint in the time that has been allocated to me, I will try to briefly summarize what I have to say. Especially, I want to discuss with these young lawyers the rules governing the attorneys at law in our country. Firstly, it is the constitution of the country. Secondly, laws made by the parliament, including the provisions of the Judicature Act number 2 of 1978, more specifically section 40, 41, 42, 43, and 44 of the Judicature Act. And lastly, the rules of the Supreme Court regulating the admission, enrollment, suspension, and removal of the members of the legal profession, and the rules of conduct of etiquette, and the rules pertaining to attire of such persons made in terms of Article 136(1) G and H of the Constitution. Now, if I refer to the salient features of the Judicature Act, I should, of course, emphasize Section 40, subsection 1 of the Judicature Act, which refers to the enrollment of attorneys at law. Now, in terms of Section 40, subsection 1 of the Judicature Act, it says the Supreme Court admits and enrolls a person as an attorney at law, such person who has to be of good repute. Now, first quality is a person of good repute and of competent knowledge. Secondly, and of competent knowledge. And thirdly, ability. So these are the main criteria that has to be considered in enrolling a person as an attorney at law, a person of good repute, of competent knowledge and ability. Thus, the admission and enrollment of a person as an attorney at law, the Supreme Court gives accreditation to his qualifications, not merely of the formal academic kind, but also of his fitness to be a member of an honorable profession like the legal profession. Now, secondly, I should draw the attention of the lawyers to Section 41 of the Judicature Act. Now, in terms of Section 41 of the Judicature Act, it says, every attorney at law shall be entitled to assist and advise clients and to appear, plead, or act in every court or other institution established by law for the administration of justice, and every person who is a party to or has or claims to have rights to be heard in any proceedings in such court or other institution shall be entitled to be represented by an attorney at law. So it shows that it is a privilege or a status that has been bestowed upon the office of an attorney at law in terms of section 41, subsection 1 of the Judicature Act. If I go further to the constitution of the country, Article 13(3) of the constitution provides any person charged with an offense shall be entitled to be heard in person or by an attorney at law at a fair trial in a competent court. In addition to these provisions, I wish to draw your attention to Chapter 5 of the Civil Procedure Code, which identifies recognized agents and attorneys at law, and specifically Section 24 to Section 30 of the Civil Procedure Code. Now, in terms of Section 24 of the Civil Procedure Code, the right of a party to be represented by an attorney at law, instructed by a registered attorney at law, has been well recognized. And also, Section 260 of the Criminal Procedure Code recognizes the right of every person accused before any criminal court to be defended by an attorney at law, as well as the right of an aggrieved party to be represented in court by an attorney at law. So these salient features gives a privilege, status, and a virtual monopoly to the position or the office of an attorney at law. In this background, I wish to draw to an important judgment of the Supreme Court by Her Ladyship Justice Shirani Bandaranayake, as she then was, in rule against an attorney at law reported in 2008, 2 SLR 73, and at page 84 onwards to 85, she refers to the judgment of His Lordship Justice Amarasinghe in Dhammika Chandratilaka versus Susantha Mahesh Munasinghe, reported in 1992, 2 SLR 303, where His Lordship Justice Amarasinghe has held, I quote, "We do not have a right to practice, but only a privilege conferred by the state, provided certain conditions are fulfilled." Justice Bandaranayake also referred to in this judgment the judgment of His Lordship Justice MacDonald in Attorney General versus Arya Ratna, 34 NLR 196, where His Lordship held inter alia, the right to practice is a revocable franchise. And also, His Ladyship Justice Shirani Bandaranayake in this judgment further refers to a judgment of the Indian Supreme Court, where His Lordship Justice Mukherjee in Emperor versus Rajani Kante Bose, 49 Calcutta Law Reports 84, and states as follows: the practice of the law is not a business open to all who wish to engage in it. It is a personal right or privilege limited to selected persons of good character with qualifications duly ascertained and certified. It is in the nature of a franchise from the state, conferred only for merit, and may be revoked whenever misconduct renders the person holding the license unfit to be entrusted with the powers and duties of his office. So what we should bear in mind is, though it is a privilege, the office of the attorney at law is a privilege, as long as we maintain good character and also the qualifications and the guidelines set out in the rules of etiquette and the laws of the country, we can hold to our office as attorney at law. But if we violate and found guilty for misconduct or negligence or any other offense, we can be disenrolled by the Supreme Court. Now, Justice A.R.B. Amarasinghe, in his well-considered book on professional ethics, of course, refers to large extent in respect of the professional ethics and the code of etiquette pertaining to attorneys at law. Now, if I draw your attention to the Supreme Court rules, which was brought into being on the 11th of February 1998, which is known as the Supreme Court of Sri Lanka, Supreme Court Code of Conduct and Etiquette for Attorneys at Law, Rules 1988, published in the Extraordinary Gazette of 7th December 1988, specifies various rules and guidelines pertaining to the conduct of an attorney at law. Now, if you carefully consider these rules, they can be divided into three parts. Firstly, duty towards clients, rules numbers 5 to 30. Then again, duty towards the court, and also which are in rule numbers 50 to 55, and also the duty towards the opposing counsel. Now, I may not embark on these rules in an elaborate manner because my learned friends who spoke to me before touched upon these rules with good examples and referred how attorneys at law should conduct themselves in their ordinary course of professional duties. Now, as you are aware, in addition to the rules, our profession is a profession which is based on long-standing legal practices and traditions. There are several traditions which we follow for a long period of time. Now, for example, as an attorney at law, must always treat court with candor and fairness and in respect and courtesy. Every attorney at law has an ethical duty to respect court and not to mislead or deceive court. Now, as you are aware, judges are human beings. Now, when you go before a judge and appear before that judge, you must be very courteous to that judge and respectful to that judge, because as a judge, he can form an opinion on you, and that opinion will be in his mind forever. And if it is a good opinion, he will always consider that opinion in favor of you. Another good tradition I learned from my seniors is never allow the bar table to be empty when the judge is on bench. Now, there are certain instances we might have to leave one court and go to another court. Now, if in the courthouse the bar table is empty, you must ensure at least to get some juniors who are seated in the back to come forward and to be seated there without emptying the bar table. Another important tradition I learned was when your witness is under cross-examination by the opposing party, never go to have a consultation with your witness. This was my personal experience about 25 years ago. I was opposed to Senior President's Counsel. I was a junior to Senior President's Counsel, Mr. Shanki Parthalingam. And we were appearing for a bank case, and we have concluded the evidence of the witness. The case was heard in the old Commercial High Court, which was in the Law Society building upstairs. In the morning, I was taking the files and going up. Mr. Parthalingam was little behind me. And when I was climbing the stairs, the witness confronted me and wanted to clarify certain things. I innocently stopped and had a chat with him. Mr. Parthalingam was coming behind me and he got very annoyed and yelled at me, "What the hell are you doing?" I was taken aback. So I stopped talking to the witness and went with him to the court. Then he explained to me and said, Varuna, you should know, when your witness is under cross-examination, you have no right to talk to the witness. That is one of the traditions we have to follow. So I think this is a good tradition these young lawyers should learn, which I have learned from one of my respected seniors. And also another good tradition was, I can remember my father was a president's counsel himself. I was in few years of practice at the time of his demise. Now, he was handling a lot of appeal briefs, and of course, the clients were not satisfied to retain me and to allow me to continue with the brief. So I had to arrange sometimes to retain senior counsel to go on with the briefs. So it came to a point that in certain cases, my father has already charged the fee, right? Now, most of the counsel said, when the counsel is deceased, if he has charged a block fee for the whole case, we will do the case free of charge. So that is another thing I learned from several president's counsel, which is a great tradition, which is prevalent in our profession. So like that, there are a lot of great traditions that we follow in our profession. And as young lawyers, you should strive hard to follow those traditions. In addition to the provisions in the Judicature Act and the rules of the Supreme Court, which governs your relationship with court, your relationship with clients, and your relationship with the opposing counsel. And even in respect to the opposing counsel, my learned friends spoke before me, elaborately stated how you should be courteous to your opponent and how you should handle the opponent without antagonizing him, right? So I think I need not elaborate on those things. And because I have already given Janaka a comprehensive note, I think which can be used for your benefit, for your future reference. Now, in conclusion, of course, I wish to quote from Justice A.R.B. Amarasinghe's book on professional ethics and responsibilities of lawyers, where at page 16, Justice Amarasinghe says like this: courts are prescribed guidelines, provided minimum standards. They do not make lawyers more ethical. In that last analysis, each lawyer must find within his own conscience and touchstone against which to test the extent to which his action should rise above the minimum standards. A code of conduct points the way to the aspiring and provides standards by which to judge a transgressor. In my view, as members of the legal profession, we should strive hard to maintain, in addition, honesty and integrity. As my good friend Mohammed Adamali stated a short while ago. Let us set an example by being honest to our clients, honest to court, honest to the opposing counsel, honest to ourselves, and above all, honest to our conscience. Thank you very much, Jan.
Thank you, sir. Thank you indeed for sharing all these valuable traditions and practices of our noble profession. With that, ladies and gentlemen, we have come to the conclusion of the main speeches of our speakers. Given the time constraint, we will have one round of questions, and I do appreciate that if the panelists could restrict their answers to 30 minutes to 30 seconds to 1 minute, if possible. I have a very interesting question coming from a solicitor who's practicing in the UK. One gentleman, his name is Prasanga Gunatilaka. Let me read out that question, and I would like if Mr. Sanjeev Jayawardena, President's Counsel, could tackle this. Let me read out to you, sir. I'm a practicing solicitor in the UK, having arrived to study at the age of 19 years and now settled here for the last 22 years. I have never studied law in Sri Lanka. What I heard a lot during the seminar by the panelists was mainly addressing the ethical stance of a lawyer. he quotes, "I'm not telling you to lie," unquote, several times, which is quite concerning. I wonder if there are really issues among juniors that mislead the court.
Anaka, there is a little lack of clarity in that question, in the sense that what do you mean issues? Is it that is he implying, it's a good question, but is he implying that actually young lawyers are sort of inclined to do that sort of thing, or is it that
Yes, I think he's trying to understand whether this is quite prevalent, like misleading court by junior lawyers. Does it happen frequently?
Not only junior lawyers. I mean, I'm sorry to say, across the board. With all due respect, it prevails across the board, from top to bottom, bottom to top, right? The issue is that the issue is that there is this concept, and I mean, we are all human beings, right? We are all human beings, and the thinking is that, conception is that actually you must win your case at all cost. That is not the case. What your only satisfaction should be is that when you went before the court, you did justice by your client by totally mastering your facts, knowing your brief, presenting the case to the best of your ability. That's all. And being an officer of court. So you must balance, on the one hand, being an officer of court, on the other hand, actually doing the best by your client. So you can do it, you can balance it. And that is the way, that is the simple way and simple formula of going ahead in court. At the end of the day, if you lose the judge's trust, if you lose the faith that the judges have in you, then it not only affects your one case. Remember, there are so many other cases that you're there. If you lose your temper with one judge, right, that judge is a human being. He is going to say, okay, hari, right? That can happen. That can happen. So we must be very, very practical. Janaka, on the assumption that you're not going to ask me any more questions, right?
No, not at all.
No. What I mean is, I please bear with me to say two things, right?
Yes.
Which I missed, right? 2 seconds. So very quickly, I'll catalog this. One very important thing that I missed, which I should have told you, is that when you're dealing with your clients, be extremely polite to them, and remember, right, cordial, because there are people who come to you with a huge problem, right? But I think judges also should understand that when clients come, right, when they are difficult with lawyers, it's not, the affectation is not to the lawyer, the affectation is the citizen of the country, because behind the lawyer is actually a client with a grievance who comes to court. And I see a lot of judges, especially of the Supreme Court, who really understand, they do understand the fact that actually, if you come to court, they don't come for fun. They have to spend money, they have to spend resources. So they actually come. Judges appreciate that these are people with actual grievance. Like that, when they come into a chamber, make sure that you're extremely polite to them and give them the best possible hearing. Because always people who have emotional torment, who come before you, it's a huge therapy for them to actually be able to talk to someone. But you must, as one of my colleagues said, you must, I think Noorani said, you must not give them false hopes. So that's one. Number two, in your practice, please, if you can, I know economic circumstances is a huge issue, but try to concentrate on quality and not on quantity. Because if you are running from court to court, if you are running, you have 100 cases a day in one court, or you're all over the place, right? You are not able to give the type of level of commitment and type of attention that is required. So always remember quality over quantity, right? I'm not saying that not to take a fair case. You can turn a black case into a good case by being smart on the law, but not lying to court, right? Thirdly, right, always remember, a bad, Justice Mark Fernandez once again told me, always a bad settlement is better than actually an argument and risking a judgment. Because when a judge, right, is away from the charm and the enchantment of the counsel's submissions, he goes back 1 month later, sits in the confines of his chamber, and is away from that influence, and actually different dynamics come into it, because he's looking at just the pleadings. So you might have a brilliant case which you lose and a really bad case which you win. So always take the settlement if it is not too bad for your client. Then remember, next one, there are only 3 people in the room, nobody else. Not your opponent, not the people who are watching. I have seen so many counsel making a point and they look back to see whether there is some kind of affirmation from the audience. Don't do that. There are only 3 people in the room, and those are your judges. They are the only people who can make a difference. One last thing, right? Before you take me by my collar and throw me out. Okay, listen. One principle for all lawyers, remember, I spoke about Murphy's Law, right? Another very important thing is this law. It's the art of warfare by Sun Tzu.
That was actually one of my questions for you, sir. Murphy,
right.
Please explain.
Okay, I will go into Murphy's. Murphy's Law is that if anything can go wrong, it will go wrong. So the potential and the probability of it going wrong is always very strongly there. So that is why if you translate into practice, Janaka, what it means is that you have to anticipate all the weaknesses of your case. Today I had a consultation. It was about a partition case. And he was saying, right? I said, මන්ද මේ ඔක්කොම මේ තර්ක ගේන්නේ අපිට ඉස්සලා බලන්න ඕනේ ඔබතුමාගේ කියන එක එකක්. එනොත් ඒගොල්ලන්ටත් ඇති දෘෂ්ටි කෝණයක්නේ. ඒ දෘෂ්ටි කෝණය අපි බලලා අපි දෙකම බලලා තමයි මේ නඩුව කියන්න ඕනේ. නැත්තම් එහාට ඔබතුමා කියමනට මම ඒක විතරක් සැලකුවා නම් මම එතන ගිහලා උසාවිය ගිහිල්ලා මට උත්තර නැතුව ඉන්න වෙයි. Right? So you have to anticipate the case. Right? Now on the Sun Tzu, that is called Murphy's Law. So you plug in all the gaps. I'm telling you, look it up. All the top lawyers in the UK and the US go on that Murphy's Law. It actually depresses you because you're always under stress, right? But try to anticipate what are the weaknesses in your case and always think what will the opponent come up. Finally, there is this art of warfare called Sun Tzu's Art of Warfare.
I've read that.
Yeah, you have read that. So that's very important. You know, for all the young lawyers, look it up. He was a famous Chinese general. He was a military general who lived between 544 to 496 BC in the Zhou dynasty, right? And this was brought up. His treatise on military strategy came up in the 20th century. So I'm going to give you a few of the things he said and translate it into real practice, okay? So the first thing he said is, all warfare is based on deception, right? So now don't misunderstand me. I'm not advocating that anybody be cunning, but I'm trying, it is obviously in a very militarized context that he said this, but let me translate it into law. All warfare is based on deception. So what does that mean in our profession? Bring up and find and bring up a point or points in law that your opponent wouldn't have dreamed of, either because he didn't read his brief properly or because he didn't look at it from that particular perspective, right? So that is the deception. Number two, subdue your enemy without fighting. What does that mean? Subdue your enemy without fighting is that other point I told you, take a settlement. Settle a matter, because a bad settlement is always better than a fight, because you don't know which way your judge is going to finally write the judgment. Right? It's number two. Number three, when your enemy is at his strongest, retreat. When your opponent is at his strongest, retreat. What does that mean? If you are in a case, and I'm being very frank, probably there are again some judges here, next time they won't give me a date on this matter, but when an opponent brings up an argument that you have not thought of, right? Be frank with your judges and my lords. This is something that, to be honest, I have not actually factored into my submissions. Would your lordship be inclined to grant me, to be gracious enough to grant me a deferment so that I can actually prepare for this and make an intelligent response? Most reasonable judges will allow you that. So that is why when your enemy is at his strongest, retreat and live to fight another day. That's what Sun Tzu says. Finally, when your enemy is at his weakest, strike so that he falls and he can't get up again, right? That was his final military strategy. What does that mean? Let me give you something far more benign and benevolent without being a aggressive general like he was. Okay, so how do you translate that into law? Finish with your strongest point, sum up with a bang, so that it keep your judges very clear on that. And now that is your opponent. Now let us say you have a difficult judge. You have 3 judges, you have a very difficult judge. Let us say you all remember what Francis Bacon said, Sir Francis Bacon said, right? A much talking judge is like a ill-tuned cymbal. That is because some judges, right, they are unable to forget that they are counsel, they were counsel, right? They are all human beings. Don't hold it against them, right? Some judges can't stop interrupting you, but you can't change them. You have to live with them, and you have to work around it. You have to circumvent that. So now, if I take my judge, in a very benign way, benevolent way, if I take my judge as my opponent, that is the difficult judge, I'll give you a little story. I was before Chief Justice GPS De Silva, Justice Kulathunga, and Justice Ramanathan years and years ago. And I was on a constitutional matter. And I had a perfect case, absolutely perfect case. And it was a sound constitutional argument that I had. And Justice GPS De Silva, Chief Justice GPS De Silva, was absolutely against me from the time I spoke. So I was confounded, and I said, my lord, with greatest respect, I cannot understand, because the facts are in my favor, the constitution is in my favor, and perhaps the other 2 lordships are also in my favor, because they were also talking in my favor. Then he leant forward across the bench. Yeah, I don't know how many of you had the fortune of knowing him. He's one of the greatest men I know. Fortunately, one of the last of that triumvirate of the good men who are still touchwood alive. And even if you see him today, he's very diminutive, very small in stature. But wherever you go, wherever he is, you will see a huge line of lawyers still running to meet him. That is because he was never rude to lawyers. He was very polite, he was gracious, and he always achieved justice. And he never shut down the cause of a client. But in this case, despite the fact that the constitutional issue was against him, he told me, when I asked him, why, my lord, what is the issue? Then he was a small-made man, right? He leant over the bench like this and said, Mr. Jayawardhan, that's the way he spoke, justice. I didn't hear him, so I said, my lord, justice, right? Now, if I take him as the difficult case, in my case, now what do? Justice is a compelling, persuasive factor. How can I say, yes, my lord, whatever it may be, your lordship should forget justice? So what I did was, I said, my lord, this constitutional matter, there are only 4 ways in which you can interpret or approach a constitution. Either you have to be an originalist, or you have to be a textualist, or you have to be a pragmatist, or you have to go on stare decisis. I said, with the greatest of respect, whichever of those 4 interpretative tools that you use, your lordship, with great respect, is misinterpreting the constitution, right? So in his characteristic style, and because he was such a mature person, he took it in the best spirit. And finally, it ended up with 2 judges holding with me, and the Honorable Chief Justice still dissenting against me. But that is how I am trying to highlight, when your enemy is, or opponent is at his weakest, because the issue of the constitutional interpretation made the issue of justice. The issue of justice with Justice GPS De Silva had to defer to the paramountcy of the constitution. So that is how I'm trying to highlight Sun Tzu's Art of Warfare. Please, all you counsel, please read it, but do not take it in a aggressive or derisive context. Please take it beneficially, and therefore I'm sure that those will stand you in good stead.
Thank you, sir.
Thank you.
Pleasure having you. Thank you for that. Okay, my next question goes to Mrs. Amar Singer. Now, Madam, as you're well aware, we have a lot of lady lawyers who have achieved high excellence in the legal field, starting from magistrates to even the leadership of the Chief Justice. But it's a compelling reason that we don't see much lady lawyers who are interested in counseling and court work for that matter. Do you perceive any plausible reason for that?
Well, if I am to share a page of my personal life, after having taken oaths in 1993, in 96 I got married, right? I won't say that I had an easy life, but after getting married, I have always managed my personal life and my professional life. And I, being a woman, I'm a mother of 2 sons. The life has been difficult. I won't say it's easy, but the reason why most of the lawyers do not become counsel is the commitment, is the devotion that you have to do for the profession. It's very time consuming, and if you are a junior counsel, your working hours will depend on the senior's work style. You face a lot of problems. Traveling back in the night alone, all those are issues for a woman. But luckily for me, I don't know, my batchmates will know I was kind of a tomboy, so nothing barred me from doing the way I wanted. So I managed to do it. But all what I have to say is, if there's a will, there's always a way. If you want to do it, you will always do it. I mean, you can come to terms with your senior. I mean, you can take the work home and do. That is what I used to do when the children were small. So as long as you do your work and you are concerned about your duties and responsibilities, I still feel that you can do it.
Yes, thank you. Thank you. As you said, if there's a will, there's a way. Thank you for that, ma'am. My next question goes to Ms. Adamali. I wanted to ask you a different question, but I think already Ms. Javadhan has answered it with regard to client handling. But let me put it to you another question. They say, Ms. Adamali, if I may quote, words are the tools of a lawyer. Why do you think language competence is important? Here, I'm not only talking about or emphasizing on English, but bilingual competence. Why is it important for a lawyer?
That's an interesting question that you posed to me, because like my batchmates, both from school and university, Sanjiva, who excels in both the English and the Sinhala languages. I, having studied in the English medium and having being the first generation Sri Lankan born in my family, my parents both being from overseas and having come here at early ages, my competence in Sinhala was quite poor. And even to this day, I think a couple of my juniors might be on this forum. They have often cracked up for my choice of a word that was inappropriate or which is similar to a word I should have used, but was the wrong one when I was in court. Language competency is critical and is important in this context. It's again the ability to lucidly communicate your thought to the decision maker, to the judge, or to the witness that you are questioning. And so I remember my very first brief, my first appeal brief, which I was fortunate to receive just a few days after I took oaths. It was a labor matter, and it was before Justice Advocacy. And the entire brief was in Sinhala, and I got it just before the vacation in December. I spent almost, 8 to 10 hours a day during the vacation, reading through that brief, word by word, looking up words that I didn't know the meaning of and trying to make head or tail of it, even though it was coming up for submissions, oral submissions, I think a couple of months later. It was a very small case, but I faced this problem. You have to learn. There's no question about it. I'm I'm proud to say that my formal Sinhala is a lot better now than it ever was, and it's grown over the years, but it still has a long way to go before it is anywhere near proficient. It's important, and of course we've managed to get by because we've had the assistance also from court. Court has been very gracious to me, known my difficulty and has assisted in times when I've been struggling. And I've had the good fortune of having juniors who have been able to assist me whenever I needed it. But as time proceeds, I think that's going to be a little more challenging because, I don't know whether that those inadequacies will be supported both by the court and by juniors, and young lawyers will need to really develop their proficiency in both languages, in all three languages if possible, because there are cases, especially in the courts of Trincomalee, in Batticaloa, etc., where a lot of the witnesses will only speak the Tamil language. And as citizens of this country, I think we all have a responsibility to be familiar and fluent with all three languages if we can. But at least proficient in two, very proficient in two, to get by with this profession. So that's the only comment I can make, and I speak of personal
Thank you for your
experience.
Janaka, before you
Yes.
go on, just give me 2 seconds of your time. This is actually, I think I'm also,
Sure,
I also have, because apart from being a panelist, I guess I'm also listening to this. So I just want to make it's really a question or more coming from Mr. Adamali. This Mr. Adamali, I had the good fortune of being both at school and also in university with, and he's not only a dear friend, but more like a brother to me. So I think I can comment without any issue. He advocated the thrill of advocacy and of being a lawyer and all the highs that you get out of it. But remember, when he was in school, he had a very lush and full head of hair, right? So during the course of this stressful journey, somewhere down the line, he has parted with that head of hair. So for all those lawyers which he advocated this, I say, please hold on to your head of hair with caution. Although I still think Mr. Adamali looks better this way, actually. Pardon the interjection.
I don't want to comment on these things. You all being batchmates, you all have the full liberty to pass on comments. So with that merriment, let me now turn to Mr. Varuna Senadira. This will be the final question for this evening. Sir, now I've seen lawyers publishing posts and videos on social media, and they're having their talk shows, private explaining various aspects of the law and things like that. So these are in form of chat shows and things like that published on media. What is your opinion on these publications, and do they tantamount to advertising?
Anaka, since the legal profession carries out a service for the benefit of the public, it is necessary that the public shall have means of knowing the members of the legal profession. So therefore, advertising cannot be absolutely prohibited. However, it is necessary that undue advertising should not be allowed or to be resorted to. And it is important that there shall be a consistency in the manner and the degree of advertising by an attorney at law. Now, if I may draw your attention to Rule 40 of the Supreme Court Rules of 1988, which I spoke earlier, it stipulates how advertising could be done. Therefore, as set out in Rule 40, displaying of a professional name board at the office or residence of an attorney at law and in professional stationery and name cards would be proper. However, illuminated nameplates or boards showing the direction to the office of an attorney at law should not be used. That is specifically prohibited by Rule 40B of the Supreme Court rules. Further, advertising in any manner for the purpose of unfairly extracting professional work for the attorney at law should not be resorted to under any means. As an attorney at law, you have to be very careful about these guidelines which has been specifically set out in the Supreme Court rules, which should be zealously guarded by us. And unfortunately, there were certain issues I got to know. And I think since they have been inquired into by the Bar Association of Sri Lanka, I think I need not embark upon those things. And this is a, I think, area where all our young attorneys at law should be very careful in advertising themselves. They should confine themselves to the provisions of the rules, specifically Rule 40, which permits what you can do and what you should not do.
Thank you, sir. That answers. Okay, with that, we have come to the successful conclusion of a very enthusiastic, vibrant session. I thank all the panelists for taking off their busy schedules and joining us today at this session. Over to you, Joshua.
Thank you, Mr. Basurya. Well, ladies and gentlemen, we've certainly heard and learned from the very best. I must thank our distinguished panelists for that enlightening and inspiring session. Thank you for sharing your knowledge and experience with us today, and for also giving us a little insight into your vibrant careers. I am certain that our viewers tuning into this webinar gain something that would no doubt prove to be valuable in their lives and careers. So, ladies and gentlemen, till we meet again next week, have a good evening and a safe week ahead. Thank you.
You must say good night now.
My apologies.
Thank you, sir.
Thank you all.